Morning, everyone. It's a little after 9, and so although the weather may be delaying a few of our in-person participants, we're going to go ahead and start. My name is Tom Fair, as some of you know, and I am part of the Thompson Hine Office of General Counsel. Today, I am joined with the other members of the Office of General Counsel, Jen Roach, J.A. Schneider, and Amy McClurg, and together we'll be presenting today's seminar, Ethics 2023, Avoiding Hidden Hazards. Last week, I attended a seminar which promised to be a rollicking adventure through ethics issues in 2023. I'm not going to promise rollicking this year, but I am going to promise some interesting stuff, including stuff that's very important for people engaged in the corporate practice. When we talk about the Corporate Transparency Act that's about to take effect, we're going to talk about multi-jurisdictional practice, which also impacts everybody, whether they know it or not, including two people at the table in front of me. And we're going to talk about some discriminatory behavior that lawyers were engaged in 2023, which will be perhaps a little bit on the rollicking side. And we're also going to talk about artificial intelligence, which is actually how I've been performing my functions for the last 10 years, even though nobody knows it. So before we begin, I must address a few housekeeping items. Today's program will be recorded, and we will send a link to all attendees within 48 hours of our presentation. The presentation is intended for general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual speakers, primarily me, and do not represent necessarily the opinions of clients, affiliates, or of Thompson Hine. The content should not be taken as advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can, both during the presentation and at the end of the program. If we don't get to your questions, we'll follow up after the program by email or by phone. We will be offering CLE credit for today's webinar. Please be sure to complete the verification of attendance survey. A link to the survey is included in the agenda that can be found on the handout section of the control panel located on the right side of your screen. We will also paste the link in the chat at the end of the program. I will announce the tracking codes for each presentation at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides, as well as bios of today's speakers. For those attending in person, please do not forget to sign in and sign out. We would appreciate it if you would take the time to complete the evaluation form on your table. Again, thank you for your interest, and we will now get started with Amy McClurg and Jen Roach on multi-jurisdictional practice and the unauthorized practice of law.
Good morning, everyone. My name is Amy McClurg. I'm Assistant Counsel in the Office of General Counsel, and it is a pleasure to be presenting the topics to be discussed in our first segment. This first segment is designed to provide a general framework to analyze issues as they pertain to multi-jurisdictional practice, the unauthorized practice of law, and remote practice as well.
So this is Jen Roach. You can't see me because I'm off camera because Amy's going to be doing most of the talking, but I'm going to ask her some questions and sort of set the stage for the topics that she's going to talk about today. So Amy, first off, we hear about UPL a lot. What is it and what are the rules of professional conduct today about it?
Sure. So the unauthorized practice of law is just the practice of law in violation of ethics rules, statutes, or other applicable law. For purposes of this segment, we're going to be analyzing it mainly in the context of Rule 5.5 of the Ohio Rules of Professional Conduct, as well as a few other rules in other states.
And I think we've got a slide on Rule 5.5 if you want to stick it up there so everybody can read it while you're going through here.
There we go. Okay. So, all right, so Rule 5.5A is, and B, they are just the general prohibitions against the unauthorized practice of law. So for instance, A, if you were, as an Ohio lawyer, to go into another state that you weren't generally licensed to practice, and that state determined that you had violated their rules on the unauthorized practice of law, or UPL, it could be said that you also violated Rule 5.5A. As far as Division B, lawyers who aren't generally admitted to practice in Ohio shouldn't have a continuous presence here. And that can include a virtual presence as well. And in the comments to the Ohio rule, they say, they give an example, which could be targeted advertising.
Okay, so what is multi-jurisdictional practice and how does it relate to UPL? And then the second question is, every instance of multi-jurisdictional practice going to be considered UPL?
So multi-jurisdictional practice is found where a lawyer is licensed in one jurisdiction, but they're allowed to provide legal services in another jurisdiction, though they're not generally licensed to practice in that jurisdiction. So multi-jurisdictional practice is permissible conduct that's authorized by rule or exception or other applicable law. When that conduct exceeds what's authorized by the rule or exception, then they're entering into UPL territory. So you could be, appearing in court, that's something that should raise a red flag, but also less obvious things like filing a legal instrument in another state could raise a flag that you need to look a little further. So no, not every instance is going to be the unauthorized practice. There are certain exceptions to be found.
And can you talk for a few minutes about the general kinds of multi-jurisdictional practice that can lead to UPL and give some examples of situations where a lawyer should take a look at 5.5 and the relevant jurisdictions and its exceptions to see if they fit within those?
Yep. So anytime that you're going before any proceeding in another state, visiting or working with out-of-state clients, or dealing with property that's located in another state, doesn't mean you're automatically committing UPL, but these are the types of activities that should raise a not a red flag, but raise a flag that you need to check to make sure that your conduct is permissible.
So what are some of the risks in engaging in UPL?
Well, there's many risks. There's risk for yourself, there's risk for the firm, and then there's risk for your client. So as we mentioned in the example of 5.5A, you could be disciplined in not just Ohio, but you could be disciplined in the state that determined you violated their rules as well. A court could give you a hard time saying that your services were not authorized, and so you may have a hard time collecting your fees. And then as far as your client, the unauthorized practice of law could lead to the striking or nullification of filings. So that can be problematic on many fronts.
You talked about the prohibitions in 5.5A and B, and also mentioned that there are some exceptions. What are some of the exceptions that you see in the different states' rules of professional conduct that apply most frequently?
Sure. So the way I like to break down Rule 5.5, at least in Ohio, is the first divisions, A and B, are just the prohibitions on unauthorized practice of law. Division C is where you would look if your services are temporary in nature. So you're looking for an exception, you're wanting authorization that this is multi-jurisdictional practice, it's permissible and not UPL, but your services are temporary in nature. You'd be looking at Division C for services that you intend to be more systematic or continuous. You would want to look at Division D, and then E is just basically to tell lawyers that, hey, if you're going to be practicing pursuant to some of these exceptions, you need to make sure that your jurisdictional limitations are in fact set forth. So let's take a look at C, so Division C in the Ohio Rule 5.5. So as far as paragraph 1, it's pretty straightforward. the client and public is served when an out-of-state lawyer associates with an Ohio lawyer. As far as paragraph 2, that is a little bit more complicated. So we'll take a deeper look at the preliminary considerations. So a lawyer must be admitted in another United States jurisdiction. When they are saying admitted, that doesn't mean that you could be on inactive status. That means you're actively admitted in another US jurisdiction. So you're in good standing, meaning you're not suspended, and then you're regularly practicing law. So if a lawyer can, meet the preliminary hurdle, then they can go to paragraph 1 or paragraph 2. Paragraph 2 is broad, but a little bit more complex. So the services could be reasonably related to a pending or potential proceeding before a tribunal in this jurisdiction or another jurisdiction, if the person is authorized by law or they expect to be authorized to appear.
Okay, so you talked about what the rule says, and let's look at some examples of how it's been applied. In Ohio, the case In re Jones involved an attorney who was licensed in Kentucky, practicing Kentucky law, but was practicing out of an office located in Ohio. So how did the court conclude that this is not the unauthorized practice of law?
Well, first, the Board of Commissioners on Character and Fitness, they did think it was the unauthorized practice of law. And many of you have probably heard of this case at one point or another, but a lot has changed since. But the Board of Commissioners thought that Ms. Jones had violated Division B, paragraph 1. So as you may recall, that's the prohibition against lawyers who are not generally licensed in Ohio from having an office or other systematic and continuous presence. They said that Ms. Jones could not be regularly practicing law in Kentucky because she was living and working out of Ohio, and that she had been doing this for a few years. So how could somebody say that her services were being provided on a temporary basis? So the board, also Ms. Jones was trying to apply to be a barred attorney in Ohio. And so they were recommending that her application to be barred in Ohio be disapproved. So the timeline is important here. So Ms. Jones worked for a Kentucky law firm. And then for personal reasons, she decided that she wanted to move to Ohio when the Kentucky law firm merged with the Ohio firm. So in October of 2015, she applied to waive into the Ohio bar, but it wasn't until November of 15 that she moved to Ohio and started working out of the Ohio office. And this was a key factor in determining that the conduct was temporary. So the comments to the Ohio rule explicitly say that there's no single test to determine whether a lawyer's services are actually being provided on a temporary basis. But here the Ohio Supreme Court said that her services would change depending on whether her application was denied or approved. So the services are transitory. They're only going to continue until her application is resolved. So her services were in fact deemed to be temporary. Plus, she met the requirements in the exception found in Division C, paragraph 2. She hits all the factors. She's licensed in Kentucky. She's got her license is on active status. She's in good standing, and she's actively practicing law. She was going back and forth to Kentucky, appearing in front of Kentucky courts, taking depositions in Kentucky for Kentucky clients. And so the Supreme Court says, no, she hits all the factors here. Her services, although they were being provided sometimes out of her Ohio office, were related to pending or potential proceedings before a tribunal. So she meets that. In this or another jurisdiction, yeah, they're in Kentucky, and she's authorized to appear in such proceedings because she is fully admitted and in good standing in Kentucky. So her conduct was deemed to fit within the exceptions of C2. She was determined, so they said, no, she did not engage in the unauthorized practice of law, and therefore she possesses the requisite character and fitness. Admission approved, and Ms. Jones was admitted to the Ohio bar. But so much has changed since then. So my takeaway is this. I think that the decision probably would have been the same. I don't know that the analysis would have been. So sometime after this case was decided, Ohio formalized what is our practice pending admission rule. So now if an attorney from another state wants to apply to waive into the Ohio bar, maybe take the Ohio bar exam, or transfer their UBE score, they can apply to practice pending admission. And in that case, they can actually apply, or they can actually practice Ohio law. Whereas Ms. Jones was just, her practice was only authorized because she was only practicing Kentucky law. Another thing that's changed, and in 2021, Ohio authorized remote work. So this, in a sense, could be deemed remote work. So again, I don't know that the decision would have changed whatsoever, but there could have been other rules that were analyzed instead of this one. So this case was only decided 5 years ago, and we've had 2 significant changes since then.
So the next case that Amy's going to talk about is a cautionary tale of no good deed goes unpunished when you try to help your in-laws in a dispute with their condo association. It was a Colorado lawyer who was trying to help out his Minnesota in-laws, and the court here took a different view of 5.5C2, and we just wanted to illustrate using these 2 cases how the jurisdictions that you're practicing in really matter, and looking at the ethics opinions and case law to determine what constitutes UPL.
Right, so here the Colorado lawyer never left his office. He'd been practicing for 30 years. Debt collection was part of his practice. He gets a phone call from his in-laws asking for help because they have this judgment against them from the condo association in Minnesota. So what does any good son-in-law do? He contacts the Minnesota attorney and he via email. So they're exchanging a couple dozen emails over the course of a couple of months. And he's trying to assist his in-laws in their troubles with paying this debt. So the Minnesota attorney, he warns this attorney in Colorado, and he says, you're engaging in the unauthorized practice of law. To which the Colorado attorney says, no, if this goes to court, it's fine. I can get local counsel. I'll just apply pro hoc vice, it's fine. So they exchange emails, and the Colorado attorney offers a settlement, and the Minnesota attorney in turn files an ethics complaint. And so Minnesota essentially says, okay, well, you have violated our rule 5.5A. And that's a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction. They said, based on your representation of Minnesota residents, your in-laws, with respect to a Minnesota judgment and a matter governed by Minnesota law, in an attempt to negotiate with a Minnesota lawyer via email, but nonetheless, that's a violation. And he said, no, this Colorado attorney said, no, I wasn't in Minnesota. I wasn't practicing Minnesota law. And even if I was, my conduct is authorized under this exception, this 5.5C2, because I could associate with local counsel if I need to, and I can be admitted pro hoc vice if I need to. And there is a potential proceeding because I guess my in-laws could go to court. And so the director argued, and persuasively in this situation, no way. You are negotiating a potential debt resolution here. This rule requires more than just speculation that you can find local counsel. You need to actually take steps to show that was feasible, so that you could be admitted pro hoc vice. And there's no indication that you took any steps to secure local counsel or investigate the possibility of pro hoc vice admission. And the director also said the chances of this ever going to court are really low. So you can't reasonably rely on this exception. So the attorney said, well, that's fine. Okay, then, well, what about C4? C4 is a catch-all. And I'll get to that in a later example, but this catch-all says, okay, if the services aren't related to proceedings in a tribunal, and they're not related to, for instance, all like ADR proceedings, if they're not related to any of those types of proceedings, and they arise out of or they reasonably relate to the lawyer's practice in a jurisdiction where they're licensed, then there's an argument that the conduct is authorized. So the Minnesota Supreme Court looks to the comments in their rule, and this is why comments shouldn't be overlooked, and they're looking at the factors that would show that certain conduct is in fact reasonably related. And some of the factors were that the law involves a federal or nationally uniform body of law. They said, no, that it doesn't involve that. Multiple, or the law of multiple jurisdictions, no, not the case. Prior attorney-client relationship, no. While the clients were his in-laws, they didn't have any former client relationship. And just because he practiced debt collection out of his office in Colorado does not necessarily mean that the services were related. So just want to show you what, so anyway, so he was found to have engaged in the unauthorized practice of law. He was given a public reprimand, or excuse me, a private reprimand. And in 2019, the Minnesota rules were revised. So now the catch-all actually includes another little security blanket, and there's an exception if the representation involves a family member. So the takeaway here is that when you're bringing in business through the normal channels, through the office, through the normal new business intake channels, or matters for existing clients, you may be more aware of UPL issues as they cross your desk. But UPL issues can arise in many different forms, and this is a really good example of don't let your guard down, because here I'm sure there was no formal retainer agreement, etc. He's just trying to help out his in-laws, but opposing counsel was not in favor of his conduct, and now he's been found to engage in the unauthorized practice of law. So it happens just like that.
So at least in Minnesota, you can help your in-laws, but that's not part of the rule in Ohio, right?
Correct.
So,
correct, right.
Be careful.
And as part of your general framework, you always have to look at the rules in Ohio, and then the jurisdiction where your conduct is directed.
So switching gears a little bit, what if an Ohio attorney comes to you and says that a client wants to initiate arbitration in California against a California company for a breach of contract claim or something like that, and the arbitration by contract has to be venued in California? What does that UPL analysis look like?
Yeah, so you're going to start out and you're going to look at the Ohio rule, and Ohio has a carve out for arbitrations. So then you would go to look at the California rule and take a look at their division A and B. And as you can see, there is no temporary practice exception carved out into their rule. So automatically, you're going to be looking at other bodies of law, statutes, rules of court, etc. When I have a situation like this and I'm looking at another state and I see that there's no temporary practice exception carved out into their rule, I'm automatically going to take a look at their state bar website, because oftentimes that'll kind of give you a heads up of the rules that you need to explore. And here that is no different. So here in California, the rule is going to be a little bit different than Ohio. Here, if you're wanting to participate in this arbitration, you would actually need to apply to their out-of-state attorney arbitration council program through their portal. which is really interesting. You'd need to associate with local council. There's, pay a fee. There's all sorts of hoops that you need to go through, and they're very specific. So, California is one state where, I don't immediately go to the ethics opinions or, some of the other resources. I really start to look at their state bar website every time I need to analyze a UPL issue out of California.
And this is an example too, right, of where the rules of professional conduct aren't enough. You're actually looking at their rules of civil procedure in California because they don't account for that in their rules of professional conduct.
Right.
Which is also different in other states. So let's talk about Florida. We'll change up the hypothetical a little bit. If your Ohio lawyer wants to initiate an arbitration in Florida, what would they have to do differently than what you just talked about in California, for example?
Yeah. So for Florida, you can see, so you'd always start with the Ohio rule, and then you would go to Florida's rule 5.5. And so Florida's rule 5.5 does have a temporary practice exception carved out, so that's nice. And in the example, if there's an Ohio attorney for Ohio client, it's going to fit nicely into Division C3A. But you always need to read the comments, because backing up, if I were to just look at this rule, I would think that services provided for an arbitration would just be authorized. But if you read a little further into the rule and you read the comments, you see that there's actually more to this. So in the case of the court annexed arbitration, you actually would need to obtain pro hoc vice admission. In the case of an arbitration that is not court annexed, you would still need to file a verified statement. And then if the arbitration was an international arbitration, you may not have to do either of those. But nonetheless, this is why you don't ignore the comments. Because my reading of the rule would have, I wouldn't have come to this conclusion absent reading the comments to the rule. So now you're wanting to know, well, how do I go about, filing the required documents? And I always go back to the state bar. So I go to the website of the state bar, and Florida, just like California, provides, reference to the relevant rule. And instructions on how to file and what to file.
Okay, another area where we often get questions, and lawyers may sometimes get tripped up and don't think about UPLs in responding to subpoenas for their client's documents or perhaps deposition testimony. What does that analysis look like under Rule 5.5C?
Yeah, so we're going to take a look at the model rule here. And so the model rule has the catch-all exception in Division C, paragraph 4. So if your services aren't in connection with proceedings in front of a tribunal, and they're not connected to an arbitration or other BDR proceedings, you could look to 5.5C4. And this is where you really need to analyze whether the services arise out of or related to the lawyer's practice in the jurisdiction where the lawyer is authorized to practice. And this is where you need to look at that state's rule, and you need to look at the comments to the rule. You need to look at their ethics opinions. You really need to see how the state views this catch-all exception. As you can see with our Minnesota-Colorado case, you don't want to try to make your facts fit something where they don't. So for instance, you get a subpoena dugas tecum, but you know that this is for a non-party. Your client's a non-party. So is it really plausible to say that you would expect to be admitted pro hoc vice? No. Is it related to an arbitration? No. So fortunately, the model rule has been adopted. The model rule 5.5C4 has been adopted in many states. So there's a good chance that when you are analyzing this type of situation, that you are going to see this type of catch-all. And that would be the type of provision that you would want to rely on. It's going to be different if it comes to depositions. So here, let's take a look at what Ohio says about depositions. Fortunately, in Ohio, in 2022, the state of Ohio, the Board of Professional Conduct issued an opinion, and this all about depositions. And it's really helpful to out-of-state lawyers, but it also shows you how you start with what an Ohio lawyer can do. So here, this opinion says that Ohio lawyers can take depositions in states outside of Ohio, even if they're not licensed to practice in those states, so long as state allows it. So the 5.5A language, in a sense. But then they also go on to talk about what out-of-state lawyers can do. So C1 allows out-of-state lawyers to associate with lawyers admitted in Ohio, so long as they actively participate. So that just involves regular contact. And the opinion actually says that the out-of-state lawyer doesn't even need, the Ohio lawyer doesn't even need to accompany the out-of-state lawyer at the deposition. They just need to make every reasonable effort to be available to consult if necessary. Likewise, Division C, paragraph 2 allows an out-of-state lawyer to take depositions that are reasonably related to proceedings before a tribunal in Ohio or elsewhere. And Division C, paragraph 3 and 4 also allow attorneys providing services that are related to arbitrations or other ADR proceedings to take depositions that are related to that, and for out-of-state lawyers to engage in depositions that are related to non-litigation work. So Ohio pretty much just gives you 5 green lights there to say that, you know, depositions are basically okay in a lot of circumstances. So you may think, well, you know, is that going to be true in every state? And Texas is a very good example of how that's not always the case. So you're going to take a look at the Texas Rule 5.5, and you can see that there's no temporary practice exception. So you're going to have to be looking to other rules here. And let's see here. Here, if you look at the Texas Board of Law Examiners website, they actually they lay it out for you. And sometimes going to these types of websites are honestly the best starting place. And sometimes, despite the fact that you've read the rule in every state, you've searched for every ethics opinion, you've even looked for case law to see if there's anything to tell you that you can or cannot do something. Sometimes it's actually, oftentimes, in my experience, it's the state bar website or something similar like this Texas Board of Law Examiners website that tells you, that gives you your answer. So here in Texas, you know, if there's suit on file in court, in a Texas court, then you are going to be subject to at least the fee requirement, if not more. Also, I want to give a non-litigation example. So there's a lot of rules that pertain to practice in court, but sometimes non-litigation activities are they're just not as widely talked about. Alabama has actually written in their rule authorization for certain types of temporary conduct that are authorized, and they are specifically in a non-litigation context. So for instance, if you're wanting to know whether or not you could record a deed on Alabama property, or you wanted to file a legal instrument, this is where you would look. Unfortunately, you're not always going to have the exact conduct that you're looking to find authorization for. It's just sometimes it's just not going to be in there. Oftentimes it's not going to be in there. But this is an example of what to look for.
Amy, before you jump into the remote practice, we had one question on the web. If an attorney lives in one state but does transactional work for clients in other states, is that UPL? And the answer is right, it depends.
Right. Yeah, absolutely. I mean, I don't think there's any way to answer that. You would need to figure out exactly what specific conduct they were talking about. You need to look at the state in which the conduct was directed. There's too many factors to just.
And even where the client's located, right?
Where the client's located, absolutely. Yeah, absolutely. So too many factors to say whether it's authorized or not.
Who can answer questions like that?
We can. Okay, so we have just a little bit of time left for this first segment, so I'm going to try to zip through this as quickly as possible. I mentioned earlier when talking about the Jones case that case might be analyzed differently today than it was back in 2018. And if you look to Division D, Ohio authorizes remote practice under certain circumstances. So remote practice in this context is not that you're licensed in Ohio and on Fridays you work from home at your Ohio office. What I mean here is that you are you're licensed in one state and you're practicing the law exclusively of that state, but you're living in another state where you're not licensed. And that's what that's what I'm referring to for purposes of this remote practice discussion. So you read the rule, and if you're not clear whether or not Ohio authorizes remote practice, you of course go to the comments, and comment 22, they spell it out and they say, yes, remote practice under certain circumstances is in fact authorized. However, you can engage in other conduct that can break these UPL rules. So this isn't complete freedom to just do whatever you want. You still have to work within the parameters of the rule. So what are other states saying? This is really interesting to me because there's a handful of states, actually 16 states that address the remote work and the rules of professional conduct. There's 12 states that have issued ethics opinions that analyze remote work, and then there's 23 states that are actually silent to this. And this is interesting because of COVID. So even though that was 4 years ago, we still have half of the states that are silent to whether or not they authorize any form of remote work, at least in the context of their rules and their ethics opinions. So, you know, around 4 years ago, nearly overnight, COVID changed the landscape of how lawyers practice. And so the American Bar Association issued this opinion 495 in 2020. And there was a host of states in 2021 that issued their opinions authorizing the practice, remote practice in their state as well. But what I think is important is that you don't want to make these opinions and these rules say something that they don't. You don't want to stretch what they're saying to fit your conduct. So, for instance, Delaware does have an ethics opinion that that authorizes remote practice, but it only speaks to Delaware attorneys. It says Delaware attorneys can go to other states and they can practice law. You know, so long as they're only practicing Delaware law, they can go and live there. But the opinion says this is silent as to whether or not out-of-state lawyers can come and work here. Florida, their opinion is actually referenced in the rules of professional conduct, and they add an extra layer, an extra requirement saying not only can so like the ABA opinion that was issued, opinion 495, a lawyer is supposed to be invisible, essentially. You can't hold yourself out as having a presence in a law where you're not authorized. But what Florida is saying is, in addition to being invisible, your law firm that's employing you, they can't have a public presence either. So there's that added requirement that you may not see in other states. The last division that I wanted, I want to back up for 1 minute and say, why is this important? So, so while COVID was 4 years ago, we all know what happened. It's really changed what is widely accepted. And so now you may have a good candidate that you want to work for, your firm, and they may not live in Ohio. They may live elsewhere. They may be licensed in Ohio, but perhaps they live in Virginia. So you would want to look to Virginia, look at the ethics opinions in Virginia, see, okay, they do authorize remote work. Ohio authorizes remote work. So long as this lawyer is acting within the bounds of the rule, then that arrangement is absolutely not the unauthorized practice of law. That's just multi-jurisdictional practice. The last part that I'll talk about is Division D, and these are disclaimers. So the example with the practice pending admission that was not available in 2018 when the Jones case was decided, but is available now. So in that particular case, let's just say you have an attorney from Michigan, fully licensed attorney from Michigan. They're applying to waive into the Ohio bar. They also apply to practice pending admission. Ohio grants their practice or their certificate to practice pending admission until their license is goes through. They would need, if they're sitting in an Ohio office, they would need to have disclaimers that say, so-and-so is only licensed in Michigan. They're with, little asterisk or some sort of disclaimer that says this attorney is not licensed in Ohio. They're only practicing pending admission. So that is, that's what Division D is intended to do. So my takeaways here are, you may not always realize that you are that a UPL issue is coming across your desk. You may not recognize it. So when you do recognize it and you do see that there may be an issue, at a very minimum, you need to look into it. And if you have any questions, call us. Thank you.
Okay. Do we need to announce the tracking code for that? That segment was T8. The tracking code for that segment that Jen just presented was THMP. Okay. So, good morning, everybody. For those who don't know me, my name is J.A. Schneider. I am a partner in the Atlanta office of Thompson Hine. My practice focuses on litigating and counseling post-employment restrictive covenants and trade secret litigation. And as of a couple of years ago, joined the office of general counsel with Tom, Amy, and Jen. So spend a good bit of my time taking on those responsibilities as well. Normally wouldn't come to Cleveland outside of the baseball season, but wanted to see a football game and get snowed on. And so accomplished both of those goals for this trip. And I can go home and tell everybody I got to play in the snow, and they'll all be very excited for me. But no one will want to come back. So in any event, talking about artificial intelligence, I did briefly consider asking ChatGPT to create this presentation for me. And then after considering it, I actually tried it, and it really didn't give me much help, to be honest with you. It sort of it produced a bit of an outline for me that looked like more work than it was worth. But I almost did it just because I thought the irony might have been worth it if I got caught doing it. But in any event, you're just going to get what I created with my own mediocre human intelligence today. So AI has been in the news an awful lot lately, and it can be, there's a lot of very exciting aspects to it and a lot of very, very scary aspects to it, depending on your perspective and maybe where you sit. But one thing we do know is that it is not going away, and it is evolving quickly. So just to sort of get a little bit of a framework of what we're talking about here, I wanted to look at a couple of the terms. And so I turned back to ChatGPT, asked ChatGPT to define some of these terms, and it froze up, which apparently is one of its drawbacks during peak hours, which 11:30 on a Saturday morning, I wouldn't have thought would be a peak hour, but apparently it was. So I went back to doing things the old-fashioned way, and I asked Wikipedia. So artificial intelligence, the definition itself, the intelligence of machines or software, nothing new there. And frankly, AI has been around for years, and we're all familiar with it, whether we realized it or not. What is new, or at least what feels new, is the generative artificial intelligence. And that's artificial intelligence that's capable of generating texts, images, other media using generative models. ChatGPT is a fancy chatbot operated by a company called OpenAI, and that's Sam Altman, or at least up until recently, Sam Altman, if you've heard the name. It's really, it's a manifestation of generative AI. It's a brand, and it's not the first AI that's been out there. It's not even the first chatbot that's been out there. We've all seen those things, and we've all seen, IBM's chess program, Big Blue, or I'm sorry, Deep Blue, has been beating chess champions for a while now. But ChatGPT may have hit a bit of a tipping point here, at least in terms of sophistication and the sense that you're working with a real intelligence, whether that's true or not. You can kind of imagine that the chess program, Deep Blue, is just gaming out millions of possibilities and doing the math to calculate what its next move should be. And that doesn't seem so different from what computers and simulations have done for years now. And it's really not that different from how ChatGPT works, which is really just predicting words and sentences instead of chess moves. But this just feels different. So for the sake of completeness, I did ask ChatGPT what ChatGPT thought it was. So I got a nice answer, and it was generally in different words than I just put it in. But there's a couple key points. ChatGPT buried the lead on itself down towards the bottom, where it says in a maybe an honest moment, it's important to note that while ChatGPT is powerful and versatile, it may not always provide accurate or up-to-date information, as its training data only goes up till January 2022. And that's accurate by all accounts I have heard, and running a few test questions on it seems to be borne out. And that's one of the biggest cautionary pieces included. The second is it tells you that additionally, ChatGPT may generate responses that seem plausible, but are not necessarily factual. So we'll see why that's important in a little bit. And maybe that's ChatGPT telling us that it's not that different from a lot of people you may run across, that their answers seem plausible, but not necessarily factual. But it's interesting, and I appreciated ChatGPT's honesty there. What are the types of things that people are asking ChatGPT to do? All sorts of things now: compose music, draft emails, summarize articles, podcasts, presentations, searching for keywords for search engine optimization, or even legal research, playing games, job searching, pretty much anything you can think of. People they're asking it to do: generate art, generate pictures. And again, as we'll see, drafting legal pleadings and briefs. So I can tell by some of the reactions, most people probably have heard the story that we'll get to in a little bit. There are, well, let's skip the slide on me here, but ChatGPT is not the only product of its type out there. The one that gets probably the most attention is Google Bard. And Google Bard works a little bit differently. Google Bard draws directly from the internet through Google search engines. So maybe it's more up to date. Of course, you've always got to consider the accuracy because it's presumably about as accurate as the internet is. So that you need to take that for what it's worth. As noted previously, ChatGPT's original training data ends with 2021 content at the end of 2021. So if it happened after then, GPT isn't going to know about it. However, Microsoft recently added a ChatGPT functionality to its Bing search engine, which essentially brings it in line a little bit closer to what Google Bard is, without being limited to the original data set that ChatGPT learned on, which was restricted to 2021. And so just for fun, I asked ChatGPT, what is Bard? And didn't get much. It apparently had never heard of Google Bard. It gave me various answers: Bard College, poets, minstrels, things like of that nature. Now you can really go down a rabbit hole with this stuff, and kind of did. It's not, in that sense, it's not that unlike surfing the internet. So I thought I'd give it a fair shake and ask the new Bing version of ChatGPT if it knew what Google Bard was. And it was a little more forthcoming on that one. It said Google Bard is an early experiment developed by Google AI, allowing users to collaborate, and even encouraged me to explore Bard further and collaborate. So it was at least honest there, promoting its competition. In terms of lawyers, specific legal applications, both Lexis and Thomson Reuters West are coming out with their own generative AI products. I've seen a couple presentations on this stuff. It is pretty impressive what it can do. And the Lexis AI product claims, in addition to sort of conversational language searches, we'll be able to do intelligent, quote unquote, intelligent legal drafting, which sounds like code for drafting legal briefs. Westlaw, the Westlaw product has largely the same capabilities. I didn't see where they have a drafting product, but I'm sure they either do or will shortly. But we'll see where it goes, and probably sooner rather than later. Obviously, the advantage that Lexis or Westlaw is going to have over ChatGPT or a similar product is really it can draw on their database of decades and decades of legal research and statutes. So it will be interested to see where it goes. But in some, I'm far from an expert on full capabilities of what any of these products can do. And as California's recently issued practical guidance summary pointed out, even for those who create generative AI products, there's a lack of clarity as to how it works. But I think one thing will predict is that a lot of what I'm saying here today will be obsolete in 6 months. A lot like Friendster became at a certain point. But for our purposes here today, it should suffice as a baseline. It's far from perfect. It may operate in less than a complete database of information, or at least accurate information. And it does not have the judgment and discretion that most people have, or at least we hope they have. And it doesn't yet have it doesn't have a license to practice law, at least not yet. So some of the pitfalls that we've been seeing with AI, and a lot of it here related to ChatGPT, is plagiarism, privacy issues, bias issues, which can implicate an Ohio Rule 8.4, loss of jobs, things like that. So some cautionary tales. It was recently widely reported that not only was AI coming up with fake product reviews on Sports Illustrated's website, but also creating fake writers as well. One writer by the name of Drew Ortiz was described himself as enjoying camping, hiking, being back on his parents' farm, except he didn't actually exist. So for what it's worth, Sports Illustrated denied the accusations and pointed the finger at a third-party company that provided some content, who also denied the allegations. But it's interesting the types of trouble that you can get into. You also may have read about a major global consumer electronics company that recently cracked down on its employees' use of generative AI. According to Bloomberg, the crackdown was prompted by the discovery of an accidental leak of sensitive internal source code by an engineer who uploaded it to ChatGPT, ostensibly to check it for errors, not realizing that he was putting his employer's proprietary source codes out there into the ether. Other reports suggested other employees at the company had used it to summarize confidential meeting notes, which is probably the more likely risk you might have in a law firm, trying to summarize your notes of witness interviews, legal strategy, things like that. By default, ChatGPT does save your chat history and does use conversations that you have with it to train its model further. And while there is the ability to disable that manually, you just need to be awfully careful with putting anything client related out there. Other companies filed suit, and a lot of companies now have restrictions on the use of generative AI. So what does all this mean to us as lawyers? The case everybody has probably heard of by now, ATA versus Avianca Airlines, was a personal injury suit brought in New York City and then removed to the Southern District of New York. This case, if you haven't read the order, I'd encourage you to do so, although so much of it is so egregious that I would hope a lot of us don't need to learn the lesson. But it is a veritable law school exam of legal and ethical issues that transpire. And really the reliance on ChatGPT is only one of them. But it is ultimately the one that got these guys into trouble and made this story particularly newsworthy. And what's interesting is this only happened, it seems like a long time ago now, and maybe in the lifespan of ChatGPT it is, but this really only took place, I think the order came out in June, and the underlying conduct was in the spring of 2023. So in any event, New York attorney Pete Laduca was the attorney of record in the case, and that was, my slide is a little off here. His colleague, Mr. Schwartz, was a New York attorney, but not admitted in the Southern District. And so Mr. Schwartz used ChatGPT to file a brief or to write a brief that was ultimately filed by Mr. Laduca in response to a motion to dismiss on a statute of limitations under something called the Montreal Convention. But that's where all the fun began. And if you read the order, it's really worse than it even sounds. I'm sure the brief looked great, but it did cite some non-existent case law. Mr. Laduca didn't check the cases, relied on Mr. Schwartz, who obviously hadn't checked the cases either. And these guys weren't rookies. They'd been practicing law for quite a while. But among other things, in addition to filing the brief with non-existent cases written by a computer program, even after being called out, they doubled down, insisting that the cases were real, filing affidavits that you could generously say contained false information, ultimately relying on the claim that they just couldn't believe the cases weren't real. They also, this may be something that it's rare that you get caught, but when a court turns a microscope on you, they ask for an extension of time to respond to some of these allegations, and included false statements in their motion for an extension of time. So there's all sorts of ethical issues here, issues with signing a brief that you did not write, issues with competency, certainly issues with candor to the tribunal. Ultimately, because courts are not the arbiters of ethical violations, they got rung up on Rule 11 violations, or alternatively, as the court said, its own inherent authority. The court did cite Rule 3.3, which is, that is candor to the tribunal. A lawyer shall not knowingly make a false statement of fact or law, or fail to correct the false statement of law or material fact previously made to the tribunal by the lawyer. These guys did both of those things. The sanctions imposed were not financially crippling. The court didn't suspend them from practice or anything like that. It was much heavier in terms of public humiliation. Aside from being in the national news, the court ordered them to write letters to each of the judges that were falsely identified as the authors of the non-existent opinions, attaching the order and transcripts of the hearings and all this stuff. So pretty humiliating. Their names are all over the country. Everybody knows who they are now, and not in a good way, obviously, and imposed a fine of $5,000. I decided to ask ChatGPT what it thought of this case. And of course, because it occurred in 2023, ChatGPT hadn't heard of it, but it did at least advise me that I might find information by searching legal databases, court records, or reliable news sources. And once again, I did I gave it a fair shake and checked on the Bing version of ChatGPT. So the Bing version that has a little more up-to-date information had a quick blurb about it. Noted that sanctions were imposed on the defendants, which isn't exactly right. So another good reason why you need to check take whatever you get with a grain of salt. Noted that there were sanctions imposed on the defendants for filing fake opinions, but no mention of its own role. No mention that it got those fake opinions from ChatGPT. So again, maybe a sign that it is pretty close to the way a lot of people might have handled that. So hopefully not us. So ethical issues implicated here, Rule 3.3, candor to tribunal. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law. These guys maybe could have claimed on the front end they didn't knowingly do it, but certainly the cover-up, once they realized what had happened, should have just come clean, which they did not do. Rule 1.1, competency. The key piece of this here, competent handling of a particular matter includes inquiry and use of methods and procedures meeting the standards of competent practitioners. I don't think anyone would argue that what these lawyers did met that standard here. Duty to supervise also gets implicated here. Arguably, the lawyer of record ratified the misconduct. A lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if the lawyer orders or with knowledge of the specific conduct ratifies the conduct involved. Arguably, by signing the brief that he didn't read or check the cases, he's ratified that conduct. And Rule 11, inherent authority of the court. Part of Rule 11B, a lawyer has to ensure that the claims, defenses, and other legal contentions are warranted by existing law. And certainly the made-up cases that they cite are not legal contentions warranted by existing law. So with that cautionary tale in mind, your duty to supervise, governed by Rule 5.1 of the Ohio Rules of Professional Conduct. Essentially, the direct supervisor or manager can be responsible for another lawyer's violation of the rules of professional conduct in a couple circumstances. One, if you order or ratify the misconduct, or two, if you later acquire knowledge of the misconduct and fail to take reasonable action to avoid or mitigate the damage caused. And again, with regard to non-lawyers, so your paralegals or assistants, basically the same. While non-lawyers are not bound by the rules, you are, and you are responsible for their conduct. Let's see. This is what ChatGPT had to say about your duty of supervision. Actually, not a bad answer. I had read some other articles, in particular an article from Brian Ott in the Ethics Council of the North Carolina Bar Association. He had asked ChatGPT the same question and got a different answer, which I'm not sure what that means, but it certainly doesn't make me trust ChatGPT anymore. But it is what it is. This is a pretty decent answer. You have a duty to supervise your staff's use of such tools, and certainly junior lawyers that are working with you. So what have we seen? Courts are starting to jump on the issue. In particular, a number of federal court judges. The first was the Honorable Brantley Starr in the Northern District of Texas, Judge Starr is requiring lawyers now to certify like your certification of word count or fonts, that no portion of any filing in your case will be drafted by generative AI, or that the language drafted by generative AI, including quotes, citations, paraphrased assertions, and legal analysis, will be checked for accuracy using print recorders or traditional legal databases by a human being before it is submitted to the court. So it's interesting, he's not banning the practice outright, but just requiring that it be disclosed. Judge Stephen Alexander Vaden of the U.S. Court of International Trade, same thing again, requiring disclosure but not banning the practice. Northern District of Illinois Magistrate Judge Gabriel Fuentes, again, same thing, requiring any lawyer using generative AI to conduct research or drafting, disclose the tool and how it was used, which is interesting. He got a little more specific about the Rule 11 implications with a terrific quote, which is why I put this one up here. Parties should not assume that the mere reliance on an AI tool will be presumed to constitute reasonable inquiry under Rule 11, because, to quote a phrase, "Sorry, Dave, I'm afraid I can't do that. This mission is too important for me to allow you to jeopardize it." And that's for the folks my age or older in here, probably 2001: A Space Odyssey. Fantastic movie. Gets a little long, like this presentation. Okay. The Fifth Circuit Court of Appeals, same thing. They're the first of the circuit courts, and to my knowledge, still the only one to put out a proposed rule on this. Essentially the same thing. Not banning the use, requiring the disclosure. And this rule has not gone into effect yet. But presumably it will in some form or fashion. So we're seeing a theme here. There is a hesitancy to outright stop the use of generative AI, and that's probably because this could be an extremely useful tool. It could really be a game changer. I mean, the way I thought when I first heard about this, I thought of, I wasn't quite in that era, but it's something akin to when this profession went from books and libraries to LexisNexis and Westlaw online searches. But the industry survived that transition, and it's hard for us to imagine going back to hopping in a library and doing research with the books. And potentially 3 years from now, we'll be talking about the days of remembering when we were associates and having to sit there on a computer and sift through all these things. But the orders do require transparency and supervision. And the supervision part of it, you know, maybe there is, or maybe there will be a program that can zip out a brief or zip out a legal memo, but you're still going to have to go in, read those cases, make sure there's all sorts of moving parts in any given case to figure out, you know, is there something, this case sounds really good for me now, but is there something buried in the bottom of it that's fatal? It's going to knock out some important claim on a different issue. So always need to be aware of those things. State bar associations getting in on the action as well, in addition to the ABA, handful of task forces in different states and governing bodies being created. California's put out some guidance for the use of generative AI. Florida's got a proposed advisory opinion out there that's actually pretty good. And it notes that lawyers using generative AI must take reasonable precautions to protect the confidentiality of client information and develop policies for the reasonable oversight of generative AI, and also to ensure fees and costs stay reasonably in line. And specifically, the proposed opinion says a lawyer must review the work product of anything produced by artificial intelligence, and including specifically verifying the accuracy and sufficiency of the research. So that's pretty good advice, whether you're using AI or not. And with that, I guess there were a couple more. Michigan has put out an opinion on judicial officers, but I would expect to see a lot more of this stuff. I'd be surprised if by the end of next year, every state hasn't addressed this in some way. Unclear if ethical rules and various rules of professional conduct will need to be changed, or whether the existing rules are sufficient to cover this. I suspect there'll be some movement there, but not a complete overhaul. But we shall see. Interesting field, and really excited to see where this goes in the next 6 months to a year. So thank you for your time. Oh, I love this. I love this meme. And I really couldn't figure out a decent place to throw this in there. I'm not quite so unoptimistic about where we're heading here, but that's one possibility. So watch your hands. Okay. Tracking code for this segment, THAI 21. Thank you, everybody.
Any questions?
Does anyone have any questions? Mookie.
I have a question. Have you seen any courts, suggesting or putting rules out that lawyers need to be using AI because it's a new technology, just like kind of like Westlaw or online research functions? I saw a lot of stuff about being cautious about using it, but have you seen anything about like an expectation that lawyers will use it in the job?
So the closest was and I don't know how to go backwards on this, but the closest was the Michigan opinion directed towards judges. The judges ought to be familiar with it and keep up with the technology. And I suspect that's a warning to the judges to say, hey, watch out for what the kids in front of you are putting out there. But no, haven't seen any guidance requiring that, other than, and I don't know if it's a specific rule, but you do have an obligation to keep up with, all lawyers have an obligation to keep up with the technology and innovation and things like that. I thought it was interesting that the federal judges that have put out guidance are not the old guys like me or Tom or whoever. They were a couple judges in their early 40s that are getting on top of this. I would have expected that it's an 85-year-old judge that's going to say, I don't want this in my courtroom, or something like that. So to answer your short answer to your question is no. But you do have a duty to be on top of this, and even if it's not a ethical duty, the marketplace is going to be overrun by this.
Yeah, I've seen client guidance documents that are saying you should use it.
I think we're gonna see an outside counsel guidelines more and more would be my guess, yeah.
Mhm.
Whether you should or shouldn't, and they be conflicting, right?
Yeah.
Well, it is conflicting. I mean, we've already seen requests from clients asking how they're using it to reduce their fees. So you're getting a push from some clients to use it. I do think the other thing in terms of competence is we now all have to be aware of the fact that AI doesn't just write briefs, it can create evidence. And the deep banks are something that we're gonna see more and more, and we're gonna have to be on the lookout for it as part of our competence of representing clients. Okay, so I think we're on for a 15-minute break. We went a couple minutes over, so we'll come back at 10:35.
Thank you, everybody.
All right, we're going to start 1 minute early. By the time we.
I don't know. You ready?
Yeah, are you good? Okay, great. I wanted to read the codes again because I think some people were maybe having trouble online hearing them. The first session code was THMP 11. That's THMP 11. And the second session code was THAI 21. THAI 21. So, okay. With the housekeeping out of the way, we'll turn to our next section, which is about the Corporate Transparency Act and ethical considerations relating to that. While we were sitting here in this presentation, I literally got 4 emails from third-party vendors who want to assist our clients with Corporate Transparency Act compliance. So if you haven't gotten those emails yet, I'm sure you're going to start getting them. And I did, when preparing this presentation, ask ChatGPT, what is the Corporate Transparency Act? And I got an answer, which was, it's part of the Anti-Money Laundering Act of 2020. And that was it, because it stops at January of 2022. And all the regulations that have been promulgated to actually put into effect the Corporate Transparency Act happened after that point. So we are finally, though, on the eve of having to deal with the Corporate Transparency Act. It goes into effect on January 1st. The regulations have been promulgated by the Financial Crimes Enforcement Network, or FinCEN. That's part of the Department of the Treasury, so that's the government agency that's got authority for administering all of this. The CTA defines reporting companies as basically, we'll get into the specific definition in a minute, but reporting companies are those who have an obligation to file a report with FinCEN. And there's obligations for companies that are formed after January 1st of 2024. They just amended the regulations within the last month to allow you to have 90 days after creation of those entities to file a report with FinCEN. Starting in 2025, that will revert back to 30 days. And then companies that are already in existence that qualify as reporting companies must file their reports with FinCEN by January 1st of 2025. We don't know what the reports are going to look like specifically yet. There's been a lot of guidance on FinCEN's website. They have a great FAQ section, but they haven't actually published yet what the reporting form is going to look like. So a lot of these third-party vendors are making guesses about what it's going to look like and how it's going to be structured and things like that. At this point, to help you collect data and help your clients collect data to comply with their reporting obligations. The CTA also, and this is the kicker here that makes things really difficult, if there's a change in ownership or control, I'll get into what that means in a few minutes, an updated report must be filed within 30 days. So those are the timeframes that we're dealing with when this act becomes effective. And for reporting companies, I've got listed there the information that needs to be reported to FinCEN, which is the name, principal office, address, jurisdiction of formation, and EIN number. For beneficial owners, and these would be individuals. We'll get into what beneficial owners means in a minute. Most likely individuals. The name, residential address, driver's license, or passport number with a copy of the same. So that's what's going to be in part required to report to FinCEN. So what is a reporting company? And we'll get into the ethics of all this later, but I sort of needed to give you a background of what the statute is for the ethical discussion to make any sense. A domestic reporting company is a corporation, an LLC, that was created by filing a document with the Secretary of State or similar governmental agency or tribal agency. So that's basically every company, right? Foreign reporting company is a corporation, limited liability company, or other entity formed under the law of a foreign country that's registered to do business in a state or tribal jurisdiction in the United States. So those definitions are obviously pretty broad.
And one thing to note here, New York has passed similar legislation. I understand that it is sitting on the governor's desk and that she has, I think, 10 days to sign it. It hasn't been signed yet, but it appears likely that it will be. That's going to apply to entities that are formed or registered in New York. And the difference between the CTA and the New York legislation is that anything that's filed with FinCEN pursuant to the CTA is going to be confidential. It's going to be maintained within the government agencies that have access to that data, but it won't be publicly available data. That's different in New York. So the New York statute will require you to file similar things or file your FinCEN information with New York, but make it public. So even though the definition of reporting company is very broad, there are 23 exemptions provided to that definition. The one that's primarily going to be used, I would suspect, by a lot of our clients is a large operating company that employs more than 20 full-time employees, has a presence in the United States, and pays federal income taxes, or their federal income taxes show gross receipts of more than $5 million. There are also exemptions for 501c3s, for entities that are subject to other reporting schemes like public companies, insurance companies, banks, or tax exempt entities, and then also subsidiaries of certain exempt entities. The exemptions are very detailed and very complicated, but they're good to know that they exist because it's not every single entity that needs to file under the CTA. And this is where our services can certainly come in to help with compliance and to figure out if a company does in fact have reporting obligations or not. The purpose of the CTA and the reason that it was enacted is to prevent money laundering, terrorist financing, and other misconduct, and to give law enforcement the information about ownership of entities in order to detect that type of illegal conduct. So we're kind of catching up with the rest of the world that already has legislation and requirements like this in place. It seems onerous to us. It's definitely a big change, but something that we all need to be aware of. So who's a beneficial owner? A reporting company that does not qualify for an exemption has to provide this beneficial ownership information to FinCEN. An owner is someone who holds or controls at least 25% of the equity of a reporting company, or individuals who exercise substantial control over the reporting company, which means a senior officer of the entity, or individuals with authority to appoint and remove officers, appoint or remove officers and directors, or who have the authority to make important decisions. It's a really broad definition, right? So there's also going to be a lot of confusion about that. And then when you go to your individuals who have exercised substantial control and tell them that you want their passport to send to the government or their address and all this personal information, you can see sometimes that folks may not be particularly excited about being identified as an individual with substantial control. Company applicants is another part of the filing requirement, and this is only relates to entities that are formed after January 1st of 2024. So if there's a pre-existing entity, they do not need to provide this information to FinCEN, but this is where law firms really get implicated because it's often going to be a lawyer or a paralegal who is providing services to a client in the formation of that entity that then would require them to file as a company applicant. So if that is the case and a lawyer or a paralegal is helping the company file, for example, if the paralegal files articles of incorporation with the Secretary of State, then they would be deemed a company applicant. Each entity can have two of them. So if a partner directed the paralegal how, what to draft and how to do it and where to file it, then they would also be considered potentially a company applicant. Lawyers can register directly and paralegals can also with FinCEN if they're providing those services and get their FinCEN number and then provide that number to the client whose services, who they're servicing in this respect, so that they don't have to provide their personally identifying information to a client. There are penalties for violations of the CTA, which is also why information that we just talked about as a company applicant is important. It's unlawful for a person to willingly provide or attempt to provide false or fraudulent beneficial ownership information or to willfully fail to provide or update beneficial ownership information.
So this is where the 30-day requirement comes in particular, if you as a lawyer file a report on behalf of your client and identify beneficial owners or those who have substantial control, and that changes, they have different directors at the company, they hire a new CEO, for example, there's an obligation to update that report within 30 days then. And you can be subject, the firm could be subject to civil and criminal penalties, which include a $10,000 fine, 2 years in jail or both if you provide false information, and then civilly $500 per day fines for failing to provide the required information. So if there has been that change to the ownership or substantial control individuals, and it's not reported within 30 days, you would be violating the act to a tune of $500 per day. So what are the relevant rules of professional conduct? 1.1, we have to provide competent representation to our clients, which is why we're talking about this, and we kind of gave you a brief background about the Corporate Transparency Act. This is something your clients are going to be asking about, asking us to provide them services related to, and it's going to impact, we'll see in a minute, practice areas just beyond corporate tax, real estate, and things like that. So it's really important to at least familiarize yourself with this so that you can issue spot and see when things like this may be coming up. And the obligation to provide competent representation includes keeping up with changes in the law, which this certainly is. So what type of practice groups are impacted beyond the corporate group? I mean, that's an easy one, obviously. But employment practices, labor and employment practice groups are implicated by the CTA. If you are drafting employment agreements, you know, for these folks who have substantial control or exercise substantial control, it's something that you want to be aware of. Personal and succession planning, trust, for example, can be subject to the CTA. So that's something that I know our folks in our PSP group are very aware of. In litigation, if you're forming an entity as part of a settlement, that could be subject to CTA reporting requirements. So something to keep in mind. Real estate obviously is another one. So with respect to employment agreements, this is just an example, and this is also something that you know, folks may want to include in operating agreements, shareholder agreements, and that is the obligation that individuals who are identified in a report to FinCEN have to provide this information to the company and keep it updated, because that's really the only way that the company can comply with their reporting requirements to FinCEN. And I know we've heard in some instances that individuals may not be you know, particularly happy about providing this information, but one way around that certainly is to think about it in advance as you're drafting employment agreements for a CEO or a COO or someone else who might fit the definition of an individual that has substantial control, and you know you're dealing with a client that is a reporting company. So what can we do as lawyers to minimize our risk? We talked about how if we're filing the reports that we certainly can be on the hook for civil or criminal penalties. Rule 1.2 provides some guidance here. That is that you can limit the scope of our representation if the limitation is reasonable and the client gives informed consent. So the easiest way to do that is in the engagement letter, for sure. These are the types of things that you need to think about in terms of what sort of services you're going to provide relative to the CTA. Do you undertake the representation related to any entity formation or CTA compliance, or is that something that you're just not, you know, willing to do or equipped to do or want to take on? The engagement letter is going to need to identify for, if you're working on a matter that's not related to the CTA, we need to say that in an engagement letter if that's what your decision is. That we're not going to take on this work or that this matter doesn't relate to the CTA, include that disclaimer. If you are working for a client to form an entity or on CTA compliance, at that point you need to define what you're going to do and won't do, and then also what the client's responsibilities are under the CTA. So the types of things to think about are whether a report is required, who's going to gather that information, who's going to file the report, will the lawyer monitor changes in beneficial owner information,
And what role will the lawyer play in updating reports? All of this can certainly be laid out in the engagement letter in advance, as long as it's documented, the client understands it and signs it. Those limitations are certainly going to be acceptable. It all depends on, you know, your choice, your allocation of risk and things like that, and handling CTA related matters. We talked before about the company applicant under the CTA. We've certainly been in meetings and discussions with other law firms about this topic. It's a hot topic because it's a service that a lot of law firms want to provide. They want to help their clients form new entities. They have to form new entities as part of transactions that they have going on and things like that, but don't necessarily want to have their, you know, paralegals or partners having to get a FinCEN number with respect to that type of work. So another consideration is whether you want to avoid or accept that applicant role. Again, it's good practice to document that in writing in the engagement letter. Certainly one thing that some firms have considered doing is having a group of people who have FinCEN numbers, and those are always the folks that then will file documents with the Secretary of State and then become the firm's company applicant. So there's a lot of different ways to slice and dice this, but these are some of the things to consider. So what's our obligation with respect to informing our clients about the CTA? Rule 1.4 communications requires us to keep our clients reasonably informed about the status of a matter. So that's the rule that triggers this here. So we do need to notify our existing clients. That certainly can be done by, you know, things on our websites, emails to clients, just general publications and alerts and bulletins. We do not, we've had this question come up quite a bit. We do not have a duty to advise former clients of a change in the law. So if you assisted in the formation of an entity 2 years ago and they're going to have a reporting requirement in 2025, you don't need to reach out to them and tell them that they have this requirement where that representation is terminated. That can be a tricky thing to figure out whether someone is a current client or a former client. We're happy to help you make that determination. But if it is a former client, you don't have an obligation to notify them. So far, there has been one state bar ethics opinion on this, and the question was asked directly, do we have an obligation to notify former clients? And the Maryland State Bar said, under 1.4, certainly no, that you don't have any duty to notify former clients under Rule 1.9. It's not in the duties that you retain of confidentiality to a former client, for example. That's just one of them that you do, but not keeping them abreast with changes of laws is not something that you need to worry about. Okay, so what if a client refuses to comply? You're providing them with CPA-related services, say that you agree to file a report with FinCEN on their behalf, but you learn that they're providing you with inaccurate information, they haven't provided you with all of the necessary documentation, or you discover that they provided you with false documentation. Because in this process of identifying who the beneficial owners are, who has substantial control, if there's a reporting obligation or not, you're going to need to review a lot of documents in all likelihood. And if you, in the process of doing that, you discover that the client's really not complying with their obligations, what do you do as a lawyer? So here's an example, hypothetical here. The client is forming a new LLC in February of 2024. No CTA exemptions apply. And the engagement letter says the lawyer is going to file the required report with FinCEN. So you're on the hook. If you're this lawyer, you're on the hook with filing a report with FinCEN and making sure that you're filing correct information. So in working to identify the beneficial owners to prepare the report, you discover that the documents provided by the client are incomplete and they're missing the names of some of those individuals who the lawyer knows exert substantial control. The client, you bring it to the client's attention and the client says, leave those individuals out of the report. They don't want to disclose their personally identifying information to the government. Okay. So you have a conundrum. You have to file the report. The client says keep information out of it that you know needs to be included in it. So what do? A, prepare the report with the correct information and file it. B, file the report as the client directed. C, immediately withdraw from the representation. Or D, discuss with the client consequences and limitations on your conduct, and if they persist, withdraw. Any guesses?
D.
Excellent. It is D. So the rules that back up your answer of D are 1.2, the allocation of your responsibilities. A subsection of that talks about how you can discuss the legal consequences of any proposed course of conduct of the client, and counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. But what you can't do is counsel a client to engage in or assist the client in conduct that the lawyer knows is criminal or fraudulent. So you'd obviously be violating 1.2 D1 if you went ahead and filed the report as the client directed. So Rule 1.16, sorry, covers termination of representation. And the instances when you can do it, one is if the representation will result in violation of the rules of professional conduct or other law. Certainly filing that report if you knew that you were providing false information would, but you have to look a little bit further because Rule 1.4A5 requires you to consult with a client about the relevant limitations on your conduct when you know that the client expects assistance not permitted by the rules or law. And in this instance, they were telling you to go ahead and file a report with incomplete information. So it would certainly fall under that rule. Any questions? Okay. The tracking code for this segment is THEC 36. THEC 36. And Tom is going to, oh no, we have a break right now. Oh, sorry about that. We have another break. Do you want to?
Okay, take the other break.
All right, we have another break. So we'll be back in 15 minutes. Yep.
We all set? We're in, as they call it, Super Bowl stretch. I'm Tom Fair, and today my topic between hacking will be the ethical implications of discrimination and Rule 8.4G. So in my presentation, I want to talk a little bit about lawyers doing things that got unwanted attention this year. Now, some say it was just a mistake, like the ChatGPT guy that JA talked about. And some lawyers getting attention say they were just exercising their rights as Americans. But in retrospect, a lot of lawyers did things that were a bad idea and worse, just might have some ethical implications. Okay, we're not going to talk about this guy, although he is in big ethical trouble. That's something for a totally different topic than mine today, and I don't want to be in a defamation suit. But I do love this picture, so I'm going to leave it up for a few minutes. Now, what we're going to talk about today is American Bar Association Model Rule 8.4G, which addresses the ethical implications of an attorney engaging in discriminatory conduct. Now, the ABA wrote and continues to develop the model rules, as most of us know, to guide states in promulgating their own individual rules. The original model rules were adopted in 1983, and they included a catch-all model rule 8.4, which listed several ways that lawyers violated the expected norms of conduct of lawyers, like violating the rules of professional conduct, knowingly assisting or inducing another to do so, or doing so through the acts of another. And that means asking your client or a paralegal or someone else to do something that you know you're not allowed to do. B is committing a criminal act that reflects adversely on a lawyer's honesty, trustworthiness, or fitness as a lawyer, which leaves me wondering which are the criminal acts that we can do that don't reflect badly on us. Answers on a postcard, please. C, engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, which is sort of the Al Capone rule, like cheating on your taxes. When you get caught doing that, you can lose your license. D is engaging in conduct prejudicial to the administration of justice, like, say, bribing a judge. E is saying that you can improperly influence a government agency or official, like telling your client that you can bribe a judge. And F is assisting a judge in violating the rules by, like, paying him the bribe. So that was at 804, stopped at subsection F, and the rule addressed nothing in the rule addressed discrimination. But one of the comments to the 83 version of subsection D addressing prejudice to the administration of justice said that a lawyer who in the course of representing a client knowingly manifests by words or conduct bias or prejudice based on race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status violates paragraph D when such actions are deemed prejudicial to the administration of justice. So while this 1983 comment addressed bias or prejudice against various protected classes, its focus was only in the context of the administration of justice. So 33 years later, in 2016, the ABA amended Rule 8.4 and added Rule 8.4G, which says that it is professional misconduct for a lawyer to engage in conduct that a lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, etc. The purpose of this amendment, according to a 2020 ABA ethics opinion, was to further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. And besides being advocates and counselors, lawyers also serve a broader public role. Lawyers should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation. The ABA's view was that discriminatory and harassing conduct when engaged by lawyers in connection with the practice of law engenders skepticism and distrust of those charged with ensuring justice and fairness. It's cute how they think that the public would otherwise have confidence in the justice system. So what exactly is prohibited in this newer rule? Comment 3 to it delineates a little bit beyond some of the more traditional workplace harassment and says that it includes harmful verbal or physical conduct that manifests bias or prejudice toward others. And it says the substantive law of anti-discrimination and anti-harassment statutes and case law may guide the application of subparagraph G. So the amendments seem to make it also an ethical violation to violate anti-discrimination laws. But the new version also gave lawyers some protection on the business end, as we do, adding that the rule doesn't limit the ability of a lawyer to accept, decline, or withdraw from representation or preclude legitimate advice or advocacy consistent with these rules. So this rule was adopted in 2016. And now it may seem to you that 2016 seems pretty recent for those progressive folks at the ABA to finally codify a rule that prohibits discriminatory conduct. And if it seems that way, you're right. In fairness, there were voices at the ABA back in 1983 demanding a rule against discriminatory conduct, at least since 1984. But those voices didn't gain enough traction to convince the main group to adopt this rule until 2016. But in the meantime, by the time the ABA acted in 2016, 20 states had already adopted similar rules prohibiting discrimination and harassment. Some were no-brainers like California, Colorado, Illinois, Massachusetts, New Jersey, New York, Oregon, and Washington, and Wisconsin, which used to be a blue state back in the day. And other states like Ohio looked less likely for adopting ethics rules that may look very woke to some today. But Ohio adopted the predecessor to 8.4G in 1994, almost 20 years before the ABA. So go Buckeyes. Many other traditionally conservative jurisdictions also beat the ABA to the progressive punch, including Indiana, Iowa, Florida, Missouri, Nebraska, and North Dakota. So in all today, 35 of our 51 jurisdictions, including the District of Columbia, have either adopted a specific rule or a rule comment stating that discrimination in the conduct of the practice of law is an ethical violation. Of the 16 states that have not promulgated a similar rule, several have said that they are studying. But so far, 8 states have specifically rejected defining discrimination as an ethical violation, most citing First Amendment concerns that had support from a number of legal scholars all over the country. Some were very unsurprising, like Montana, where the state legislature vehemently condemned the rule and said that it violates the First Amendment and seeks to destroy the bedrock foundations and traditions of American independent thought, speech, and action. Oop, wrong one. There we go, sorry. The Texas Attorney General published an opinion asserting that Rule 8.4G would severely restrict attorneys' ability to engage in meaningful debate on a range of important social and political issues, including subjecting participants in candid dialogue on topics such as legal immigration, same-sex marriage, or restrictions on bathroom usage to discipline while suppressing their thoughtful and complete exchanges about these complex issues. So that's the traditional view of constitutional protection for potty talk. My children will be very pleased. Louisiana's Attorney General also weighed in, stating that the expansive phrase conduct related to the practice of law is unconstitutionally broad as it prohibits and chills a substantial amount of constitutionally protected speech and conduct. Then the Louisiana State Bar Association Rules of Professional Conduct Committee voted not to adopt Rule 8.4G. So apparently you're ethically okay to just say discriminatory things in Texas and Louisiana. But of course, protecting speech rights doesn't address concerns about the need to sanction attorneys for discriminatory action. And the vast majority of cases finding violations of 8.4G involve actions in addition to speech, because most of them deal with discrimination in the form of sexual harassment. And in those cases, there are often allegations of unwanted touching or having sex with clients, which when I last checked was not a constitutional right. But maybe in Texas, we can work on that. So interestingly, there are a few reported cases dealing with 8.4G style violations in Ohio. And actually most happened before 8.4G was even adopted. And one called Young, decided in 2000, a lawyer was found in violation of the rules for sexual abuse of 4 separate legal assistants. And some critics complained that the text of 8.4G put attorneys at risk for disciplinary violations for engaging in social activities where verbal conduct may be seen as manifesting bias or prejudice and thus harmful. And adding fuel to the fire of the unconstitutionality claims, in the 2 years following the ABA's adoption of 408G, the US Supreme Court rendered 2 decisions regarding free speech after the ABA's adoption that also raised additional constitutional issues. In 2017, in a case called Maytal versus Tam, the court declared that a longstanding law allowing government officials to deny trademarks for terms that may disparage or bring into contempt or disrepute living or dead persons was unconstitutional because it offends the bedrock First Amendment principle, speech may not be banned on the ground that it expresses ideas that offend. Justice Alito, writing for a plurality of the court, noted that speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. In National Institute of Family and Life Advocates, decided in 2018, the Supreme Court held that government restrictions on a lawyer's professional speech are subject to strict scrutiny because they are content-based restrictions, and such laws are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests. The court observed that this stringent standard reflects the fundamental principle that governments have no power to restrict expression because of its message, its ideas, its subject matter, or its content. And the court has not recognized professional speech as a separate category of speech subject to different rules. Speech is not unprotected merely because it is uttered by professionals. So that sounds like an uphill battle for Rule 8.4G, assuming that disciplinary enforcement is government action, which it is. But maybe it's a little more complicated. First Amendment law is very complicated and frankly beyond the scope of our talk today, let alone my expertise. But at least one court has found that Rule 8.4G is constitutional. In 2021, the Colorado Supreme Court addressed this issue in a case dealing with a lawyer making an anti-gay slur in an email to his clients. Here I'm going to make two important points that are a little off topic. First, when you read these opinions, you are struck by how incredibly stupid people can be, notwithstanding if they have advanced degrees. Nothing about getting a law degree. It seems to make people suddenly develop any common sense about what they say to other people. Putting something crappy about a judge in writing is just one of the many ways that lawyers shoot themselves in the foot with emails. And it seems to me, as I've read these things and talked to people, that everybody involved seems to have diarrhea of the keyboard. We see it every day. Every year when we do training for our lawyers, I tell them all that every malpractice case ends up with a discovery request for all the emails, including internal emails. The search of those emails inevitably turns up multiple emails where some lawyer sends a message to someone that makes them or the firm look bad. Sometimes the lawyer badmouths the client. Sometimes the lawyer badmouths the case. Sometimes it's about the partner they're working for, or if you're in-house counsel, it's about management. And sometimes it's just about the clients themselves. I know that everybody feels better when we get stuff off our chest, but it's seldom a good idea. I always suggest that people feel free to write their nasty message and then keep it in a draft overnight. And then after cooling down, reread it and ask yourself a few questions like, does this email help my case or my client? Could it hurt them or me? Would I want to listen to this email being read in front of my client? Would I want it read in front of my coworker, my opposing counsel, or how about in front of the judge in the case? It's shockingly frequent that lawyers send emails where the obvious answer to any of these questions is no. I would not want these people to read this, but they send them anyway. That's the case here. So in this case called Abrams, it was decided in 2021, and it dealt with just this kind of email, and it's packed with lots of lessons from an ethical and risk management point of view. The lawyer in the case attended a case management conference with his associate before a judge who apparently felt he acted very hostile towards him. And reporting to his clients about the hearing, the lawyer sent an email that said, while I was getting your case dismissed, I was getting yelled at by Fatso. The judge is a gay fat fag. Now it's out there. Now, maybe if he'd asked himself, how would I feel about this email being read in front of the judge? But he didn't, and he sent it to his clients. So anyway, as he said in the email, his clients did prevail in the litigation, but the relationship with the lawyer went soured over a fee dispute, including because they didn't think they should pay for his associate's time, except once they learned that he was a Florida attorney without a license to practice law in Colorado. This is why what Amy was talking about earlier is important. It's always the fee disputes where the unlicensed practice issues come up. After a few months of back and forth over fees, the lawyer filed suit against the client to collect the fees. And after suing them, the lawyer got a letter from disciplinary counsel notifying him that the clients filed a request for investigation into his billing practices. Then after he got the letter, the lawyer responded, and then he billed his clients for responding to the request, which was also super smart. Then the lawyer got notified that he was being investigated for violating 8.4G because of his email about the judge, which the clients had apparently supplied to disciplinary counsel. So we can add to our list of email questions, how would you feel about having your email read by the Office of Disciplinary Counsel? Because that'll happen too. And of course, the other lesson is that when you sue clients for fees, the warts of your work get revealed. So disciplinary counsel finds an ethical violation, and ultimately the case makes its way to the Colorado Supreme Court. And among his defenses, the lawyer argued that sanctioning him for expressing his view of the judge violated his First Amendment right to free speech. And in its opinion, the court disagreed. Without directly discussing the specific level of scrutiny that often accompanies First Amendment jurisprudence, they found that 8.4G serves the state's compelling interest in regulating the conduct of attorneys representing clients and protecting clients and others in the legal process from harassment and discrimination. Now, this case was published in, oh, and by the way, he was suspended for a year, which is maybe light for what he did. This case was published in June of 2021, which is interesting because it came after a Pennsylvania case published about 6 months earlier in December of 2020. In that case, called Greenberg versus Haggerty, a federal court delved into the conflict between 8.4G and the First Amendment. In that case, a self-proclaimed First Amendment lawyer sought to enjoin Pennsylvania's adoption of 8.4G, claiming that he feared prosecution because the amendment said it was professional misconduct for a lawyer to knowingly manifest bias or prejudice in the practice of law. And here's the key part: by words or conduct. The proposed amendment, which was very similar to the ABA's model rule, said that conduct in the practice of law included participation in activities that are required for a lawyer to practice law, including continuing legal education seminars where education credits are offered. So Mr. Greenberg asked the federal district court to enjoin enforcement of the new rule and comment. The random draw assigned the case to a relatively new judge who had been appointed by President Trump. The state bar filed a motion to dismiss. The judge denied the motion, finding that Mr. Greenberg had standing because he had a reasonable fear of prosecution. He also noted that while the Supreme Court had found that the state can regulate attorney speech in court and related court proceedings, the new rule made clear that it applied to both words and conduct, and that it applied to words and conduct outside of court. He issued a preliminary injunction against enforcement of subsection G, as well as the comments. And in March of 2022, after summary judgment filings by both sides, the trial judge issued a permanent injunction. The rule, he found that the rule facially violates the First Amendment and that it facially violates the 14th Amendment. And then he permanently enjoined the state from enforcing the rule and the comment. So score one for free speech arguments. Now this raises some interesting issues. He enjoined enforcement of 8.4. That meant, I assume, that attorneys couldn't be charged with ethical violations for anything 8.4G would have prohibited, maybe even blatant sexual harassment. But the state bar appealed the ruling and the Third Circuit reversed it. But it did not decide the free speech issue. And that's because when Pennsylvania finally adopted 8.4G, the reference to words and conduct was dropped. And the comments explicitly state that the practice of law does not include speeches, communications, debates, presentations, or publications given or published outside traditional legal settings. The court concluded that because Pennsylvania's Rule 8.4 did not prohibit Greenberg from quoting offensive words or communicating controversial ideas in his CLE presentations, he would not be disciplined for his planned speech. Therefore, he lacked standing to challenge the rule and the case was dismissed. But the lower court opinion is still out there. Excuse me. Okay, let's talk briefly about some other matters where 8.4 was implicated. One was decided just about 2 months ago in California, and you may have heard about this incident. This case involved an attorney's statement on her personal Twitter account around and about the death of George Floyd and the turmoil surrounding the Black Lives Matter protests following that death. On May 28th, a few days after his death, a member of Congress tweeted about how Nancy Pelosi had canceled meetings of the House for the next month. Someone else responded, DC is about to get overrun by Antifa, get out. And this lawyer tweeted, can't wait, at least a reason to shoot them. The next day, someone tweeted a statement about Colin Kaepernick's protests and that were at NFL games that were meant to draw attention to a quote major systemic problem. And on the next day, there was this lawyer texted, "The only system is Black Lives Matter." And then the day after that, in response to another tweet about traffic problems caused by the protesters in Los Angeles, this lawyer tweeted out, "Shoot the protesters." So she was on a complete roll. The same day she tweeted to someone else, "You sound as dumb as your profile suggests. BH is full of Middle Easterners and they are huge liberals." And then when someone tweeted that President Trump should classify Antifa, a domestic terror organization, she replied, "Along with Black Lives Matter." There was also some reference in the opinion to some tweets to Joe Scarborough at MSNBC, and I think we can guess what those sounded like. So not long after these tweets, her friend informed her of complaints about her tweets from board members of the Los Angeles Police Protective League, of which she was a member. She also learned that her alma mater, USC, was taking steps to revoke her booster privileges because of what she'd said. She then deleted her account, expressing remorse for what she'd said, but the damage was done. Remember, California adopted essentially the full ABA version of 8.4 with no requirement that the conduct be unlawful or connected to the practice of law to be a violation. So when the State Bar investigated the complaints about her tweets, they charged her with 4 counts of professional misconduct, including moral turpitude by directing others to commit acts of violence. But notably, they did not charge her with a violation of 8.4G, which was the anti-discrimination statute. A 5-day trial was held before a bar judge this summer, leading to a 33-page decision. The judge noted, first, that false statements are not protected, and that advocating the use of force when directed to incite imminent lawless action or produce action, such action is also not protected. He also noted that the U.S. Supreme Court has found that attorneys are not necessarily protected by the First Amendment to the same extent as those engaged in other businesses. But he ultimately focused heavily on the First Amendment issue, citing comment 6 to the California rule, which states that it does not prohibit activities that are protected by the free speech protections of the U.S. or California constitutions. And he found that in seeking professional discipline based on thoughts and viewpoints expressed in her personal Twitter account, the bar misinterpreted the law relating to attorney speech, essentially contending that all speech uttered by an attorney is entitled to less than constitutional protections, regardless of whether the speech was communicated in an attorney's professional capacity or otherwise relates to the practice of law. The judge instead found that the full protections of the First Amendment apply, particularly where the lawyer's speech was communicated in her capacity as a private citizen, and where it was used to express her personal thoughts, emotions, or ideas, and was completely unrelated to the practice of law. He concluded that while the State Bar may have a special interest in regulating attorney conduct, that does not give it unfettered authority to regulate attorneys in their daily lives, to censor unfavorable speech that it deems reprehensible, unethical, and outside the bounds of good moral conduct expected of attorneys. So all counts were dismissed with prejudice, and that decision is currently under appeal. It's going to be interesting to see if the traditional liberal bent of the California Supreme Court leans in favor of regulating what some might call hate speech, or in favor of the traditional First Amendment free speech. So what do we take from this, from these cases vis-a-vis the First Amendment? I think it's fair to say that attorneys that engage in what has long been recognized as sexual misconduct or other misconduct with clients in the workplace or in court will find no constitutional excuse for their misconduct. But if a disciplinary authority seeks to pursue ethical charges for attorneys expressing unpopular opinions about minorities outside the workplace or the courtroom, they're going to find an uphill battle. And in many states, the language adopted may not even give them that option. I said I wasn't going to opine on the First Amendment, but I did anyway. Okay, let's talk about a few more fun cases, including 2 more from this year from Colorado, which seems to have more than its share of icky attorneys, or at least more people willing to report bad behavior. The first involves a nice gentleman named Blumenthal, who was a criminal defense lawyer. And according to the opinion, during a hearing, he aggressively leaned over the prosecutor and accused her of lying to him, and she didn't know what she was doing. The prosecutor feared he was going to physically harm her. The judge felt he was completely out of control and scary, and was also afraid he was going to hit the prosecutor, and he was using his physical stature to intimidate her. But just to be sure he had violated another rule, he made sure that when he left the table, he called her a bitch. So he gets a 1-year suspension for violating Colorado's version of 8.4G, which prohibits conduct exhibiting bias against a person based on gender toward anyone involved in the legal process. In another shining example of the Colorado bar, we have the case of Mr. Hicks. Among other problems like filing frivolous claims and not reconciling his trust account, Mr. Hicks started sleeping with one of his clients. And when texting with this woman, he sent her a text where he referred to her ex-boyfriend as a literal faggot. I'm just going to say here how much I hate it when people use the word literal, especially when they use it wrong. Maybe he meant it in the right way. I don't know, but I'm always on guard. So anyway, it appears that this text came out after the ex's parents complained to disciplinary authorities about the relationship. Further demonstrating his keen intellect, Mr. Hicks apparently made the really smart move of suing the parents for defamation, whereupon his texts with the girlfriend were discovered by the bar. So he got a 30-month suspension. Moving to the great state of Missouri, we find the case of Mr. Purdy, an 86-year-old attorney suspended for inappropriately touching his female clients in jail and in a car. He made the mistake of groping his clients in front of sheriffs at the jail who reported the misconduct. And while he might have otherwise gotten off with a lighter sentence, he was indefinitely suspended because he continued his pattern of improper sexual conduct toward vulnerable clients even after the case was filed against him. Now, for those of you out there thinking of making a comment about an 86-year-old still working and groping clients, I'd like to remind you that Rule 8.4 also prohibits conduct exhibiting bias based on age. So just saying. All right, we're going to keep our Midwestish kind of theme here. Let's move up the Mississippi to the state of Minnesota for the case of Mr. Hallinan. According to the opinion, he sexually harassed 2 young male employees. One was a 19-year-old fast food employee he met on a dating app and encouraged to apply for a job at his firm. And one was a law student who he initially met on social media and later hired as a summer intern. In this case, the court essentially rejected a plea deal and imposed a longer suspension because the facts showed that he had targeted men who were vulnerable due to their age and socioeconomic status and encouraged them to work for his firm, but then sexually harassed them. The harassment was egregious because of the number of incidents, many of which involved intimate physical sexual contact, and the lawyer's repeated exploitation of the power imbalance between himself and his employees. He also upped the ante when he threatened both of them in an attempt to keep his misconduct hidden. The court concluded that the deal to allow him early reinstatement was inadequate to protect the public and the judicial system and to defer future misconduct by him or others. And now let's head east to New York, where we have a rather strange opinion from a New York judge addressing conduct of an unnamed attorney that was handling a case in his courtroom. The opinion doesn't identify the lawyer, but goes through a long list of misbehavior in the case, including telling the court's intern, if I were younger, I would flirt, commenting on her looks, telling her he could covet her because she was unmarried, referring to the opposing counsel as darling and then correcting himself, saying he wasn't allowed to use a sexist term for a woman, telling the intern that he was a juris doctor, not a Jewish doctor, and asking the intern whether her name should be pronounced in a more ethnic manner, and then after she said no, using that ethnic pronunciation anyway. I feel like we've all met this guy at some point at the Justice Center. Anyway, the judge found these annex to be inconsistent with Rule 8.4 and required this unnamed lawyer to take classes to educate himself on non-discriminatory behavior. All right, concluding our tour of lawyers behaving badly, let's talk for a minute about some key differences between the model rule and its adopted version here in Ohio, which is similar to those adopted in a number of other states. Ohio's existing version of 8.4G says that it is misconduct to engage in a professional capacity in conduct involving discrimination prohibited by law because of race, color, religion, age, gender, sexual orientation, national origin, marital status, or disability. We compare that to the new model rule for 8.4G, which is broader, which says it's misconduct to engage in conduct that the lawyer knows or reasonably know is harassment or just discrimination based on these many categories. The different layouts make it hard to track exactly, but there's several key differences in the two versions. First, to what does this rule apply? Ohio says that it applies to what the lawyer does in a professional capacity. But unlike Pennsylvania, it does not explain what that means. All Ohio decisions deal with conduct of lawyers toward clients or employees. So we don't have anything to tell us what else is included in conduct that is in a professional capacity. The model rule talks about conduct related to the practice of law. Comment 4 to the model rule says the conduct related to the practice of law includes activities such as representing clients, interacting with witnesses, coworkers, etc., operating or managing a law firm or practice, and participating in bar association, business, or social activities in connection with the practice of law. So apparently off-color comments at the ABA cocktail hour may well be violations of the model rule, but we just don't know what counts or if that would count in Ohio. But here's where we may find the most significant difference. The ABA says that the rule applies to conduct that the lawyer knows or reasonably should know is harassment or involving discrimination. That's quite wide. As the ABA noted in its recent opinion, 8.4G prohibits conduct that is not covered by other laws, such as federal prescriptions and discrimination and harassment in the workplace. Although conduct that violates Title VII of the Civil Rights Act would necessarily violate paragraph G, the reverse may not be true. A single instance of a lawyer making a derogatory sexual comment towards another individual in connection with the practice would not be severe enough to violate Title VII, but it would violate Rule 8.4G. Ohio is very different. It applies to conduct that is prohibited by law. So Ohio, assumedly, would not impose sanctions for conduct that doesn't rise to a violation of Title VII. However, the Ohio Supreme Court has held that finding a violation does not require a preliminary finding of discrimination by the OCRC, the EEOC, or a state or federal court as a prerequisite to the board finding that an attorney's conduct violated 8.4G. And what is the scope of disadvantaged groups protected in Ohio versus the model rule? Both the model rule and Ohio's version apply on their face to discrimination based on race, color, religion, age, gender, sexual orientation, national origin, marital status, or disability. But the 2016 ABA version also prohibits conduct based on ethnicity, gender identity, or socioeconomic status. Truthfully, I'm not sure I can tell you how or if there is any way that ethnicity isn't covered by Ohio's reference to race, religion, and national origin, but they do use different words. And I assume that the ABA's reference to gender identity is broader than Ohio's reference to just gender, but that's not clear either. But it does seem clear that socioeconomic status is not part of Ohio's list of protected categories. So I guess in Ohio, you can say terrible things about poor people without risk of ethical sanctions, but if you go to California, you might be at risk. A few other key points about these rules is understanding what the rules say is not discrimination. Here's a few exceptions. A trial judge finding that peremptory challenges exercised on a discriminatory basis, say of race or gender, does not alone establish a violation of paragraph G. A lawyer doesn't violate paragraph G by limiting the scope or subject matter of his practice or by limiting the lawyer's practice to members of underserved populations in accordance with these rules or other law. And a lawyer may charge and collect reasonable fees and expenses for a representation. So I gather the intent here was to reassure lawyers that deciding not to work for poor people that can't pay their bills won't be deemed discrimination based on socioeconomic status, which is good for people on the 39th floor. What time is it? 11:52. 11:52. Okay. First, any questions? Good. Anybody feeling harassed yet? No. We have 8 minutes left to do it. Okay. I want to go through a couple hypotheticals and see what the group thinks. First one is a religious organization challenges on First Amendment grounds a local ordinance that requires all schools to provide gender-neutral restroom and locker room facilities. Would a lawyer who accepted representation of the organization violate 8.4G? Andrew?
No?
Anybody say yes? No. The answer is no. This does not involve the type of conduct covered by 8.4G. The black letter text underscores this by explaining that the paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from a representation in accordance with 1.16. In addition, the provision's next sentence further emphasizes that it does not preclude legitimate advice or advocacy consistent with these rules. Though individuals may disagree with the position the lawyer in the hypothetical would be defending, that would not affect the legitimacy of his representation. Okay. 2, a lawyer participating as a speaker at a CLE program on affirmative action in higher education expresses the view that rather than using a race-conscious process in admitting African-American students to highly ranked colleges and universities, those students would be better off attending lower-ranked schools where they would be more likely to excel. Do those remarks violate 8.4G?
No.
No, you're right. A CLA program would fall within comment 3's description of what constitutes conduct related to the practice of law, but the viewpoint expressed by the lawyer would not violate 8.4G. The lawyer's remarks without more wouldn't constitute conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race. That view, even if a controversial one, cannot be reasonably understood as harassment or discrimination contemplated by the rule. And the fact that others may find those opinions offensive doesn't make it an ethical violation. Okay. A lawyer serving as an adjunct professor supervising law students in a law school clinic made repeated comments about the student's appearance and also made unwelcome non-consensual physical contact of a sexual nature with the student. Does that violate 8.4G?
Yes.
Yes. Okay, that one was a gimme. It's an obvious violation and demonstrates the importance of making the scope of the provision broad enough to encompass conduct that may not necessarily fall directly within the representation of the client. If you are supervising law students, you're still engaged in professional conduct. Okay. A partner and a senior associate in a law firm have been tasked with organizing an orientation program for newly hired associates to familiarize them with firm policies and procedures. During a planning session, the partner remarked that Rule number 1 should be never trust a Muslim lawyer. Rule number 2 should be never represent a Muslim client. But of course, we are not allowed to speak the truth around here. Do those remarks violate Rule 8.4G?
Yes.
Yes. Even if one assumes that the associate was not Muslim, the comments violate 8.4G. The remarks are discriminatory insofar as they are harmful and manifest bias, and the partner surely knew or reasonably knew about that. Okay, those are gimmies. All right, that is our tour. That is our lessons on discrimination and how not to do it. Do we have any questions from the world, Scott? Nope. Okay, that means first I give you this tracking code, PHDR16.
You're on the chat.
Oh, good.
The links to the survey,
What's that?
the links to the survey.
The links to the, okay.
The other coach.
Okay.
Sorry.
We're so-
Okay. So we have all the codes. Thank you all for your interest and for attending today. And I thank especially Alice Armstrong, who is the unsung hero of everything that happens here. Thank you, Alice. If you have any questions or comments, reach out to Alice. If you need any information, do you have any?
You repeated all the codes again.
They're in the chat. And I will tell you, for everybody who's just listening, segment 1, THMP 11. Segment 2, THAI 21. Segment 3, THEC 36. And segment 4, THDR 16. Okay, thanks everybody for coming. Oh, Alice?
Just one more thing. I just want to make sure they fill out that survey form that's in the chat as well, because that's where they have to enter their codes.
Please fill out the survey form in the chat, because that's where you will enter your codes and therefore get your credit. Okay, thanks very much. Have a great year.
Yeah. Sorry.
Thank you.